Angela, your mic is on.
Site it down, transcribe it. Firefly, don't firefly. Firefly.
Exactly.
Download the app. Then you
Hello, good afternoon, everybody. And the class rep on mute and at least speak up to me so I can be sure I can be heard.
Yes, sir. Good evening, sir. And good afternoon, sir.
Okay, good afternoon. I hope we can start now.
Yes, sir.
Okay. Now we want to understand the nomenclatures that primary legislation has been given. If you go through books, you will come across names by which statutes have been addressed. So this is just an exercise for us to at least have a feel of that.
Okay. Good.
So number one, they are known as ordinances. Ordinances. And ordinances, these are the laws that were made for Nigeria. Uh, that is before 1954. Those are colonial laws. 1954 was when uh, Nigeria, let's say, federalism was introduced to Nigeria. But before that time, laws made by the colonial authorities at that time were called ordinances. Are called ordinances. Then after 1954, the October 1, 1954, those laws were redesignated because 1954 was when federalism was introduced to Nigeria. So at that point in time, we now had three sets of laws. The laws, that is, the laws that were assigned to the, the laws that were assigned to the federation, that is the federal government. And then we also have those ones on the concurrent list and those ones on the residual list.
Jesus.
Ola, please mute your mic.
So,
Ola, very network issue. Ola, your mic is still muted.
Oh, Alabzi.
So I'm back now. The network is been very terrible on this side, but no problem. I think you can hear me now.
Yes,
That's
sir, I
right. Can
can
you
hear you.
respond? Okay, good. So the point I was
Yes,
trying to
sir.
that legislation has been, giving names, depending on the legal regime that's in place. So, and the starting point for us in Nigeria is before 1954. Before 1954, Nigeria was ruled as a colonial state, so to say, uh, under the colonial powers, and the laws that were given to the country at that time were called ordinances. So that were ordinances, those laws were called ordinances. And the ordinances were the laws passed by the Nigerian Central Legislature. That's before October 1954. No. Then there are apart from the colony, that is the colony of Lagos, they also have the protectorates. So the protectorates were ruled using what they call proclamations. Proclamations. Now, after 1954, for example, in October 1954, the November 1954, the country gravitated to a federal system, whereby then was that the laws that were made those ordinances that were made, now had to be rooted between the legislatures of both the central and the regions. So basically, all laws that were made, that had a federal effect, or let us say that could be said to come under the federal legislature, having regard to legislative powers, that is the diffusion of the legislative powers. So those ones now were assigned to the federal government, while other laws that apply strictly to the other branches, were now assigned to the regional governments. And in 1960, the same situation obtained. So basically, what laws that were made before 1954, and they had to decide which one applied to them. So it was basically based on the legislative powers, that is the distribution of legislative powers between the federal and the regional legislatures. Now, when Nigeria became independent, then there was the law that had to do with designation of ordinances. It was called the Designation of Ordinances Act of 1961. And what that did was that all the laws which were reckoned with as, at that time Nigeria had become independent, and we now had what could be said to be our own democratic government. So all the laws that were assigned or that related to federal matters, now became acts. While those ones that were assigned or designated as regional laws, they were now addressed as laws. So you have acts of the federation and laws of the region. So basically, an act as Nigerian legislation is an enactment made or deemed to be made by the federal legislature, that is before January 16, 1966. So between 1961 and 1966, all the laws, that are federal laws were designated as acts, while those for edicts, and you have state laws referred to as edicts. So those are the names by which laws have been addressed. So you understand that in Nigeria, we have moved from civilian government to military government, from military government to civilian government. So basically, those laws, when you move from a civilian government to military, any law, any federal law that has been retained now became a decree So in terms of nomenclature, it is now addressed as a decree, while any state law that uh, survives the suspense now is addressed as edicts. Now, when the country moved again from military to civilian governments, the designation changes again, or let me change again, from being addressed as decrees and edicts back to acts and laws. So that's where laws are described. So it's the same law, but then the nomenclature changes. Under civilian governments, they are called acts and laws, acts of federation or acts of federal government. That is laws emanating from a federal legislature. And for the states, they are called laws. That's laws emanating from state legislatures or regional legislatures. For example, if you are talking about the laws of the former regions, you will find out that after states have been created, for example, Western Nigeria, we had Western Nigeria, and Western Nigeria now, we have so many states, that have been carved out of Western Nigeria. You have Ogun State, Oyo State, Osun, Ekiti, So all the laws that were designated laws of Western Nigeria, are now become laws of each of those states, except until they are maybe repealed. Otherwise, the states take over those laws and they continue to be their laws. So that is it for that in terms of the designation of Nigerian statutes. Any question before I move on?
Yes, sir. Good afternoon, sir.
Yeah, good afternoon.
So, sir, before 1964, you said they were called ordinances. I wanted to ask, during the time when the general law, the federal laws were called ordinances, what was the name of the
I can't hear
regional
you.
laws? Like,
Can you repeat it? Can you come your question again? I can't hear you clearly.
so I said before 1964, they were called, like the general laws were called ordinances. I was going to ask if regions still had laws, and if they did, what were they called, sir?
Mr. Kunke, I can't hear you. The network is not allowing to get across to me well. Are you typing your question? Let me see if you type your question, I might be able to. Let me see the chat box. Hello, can you hear me? Hello?
Yes, sir. Yes, sir. I can hear you, sir. So I'm trying to type it since my
Okay.
network is. Yeah.
Okay.
Good afternoon, sir.
Yeah.
Good afternoon, sir. So I want to make a request,
Good
not a
afternoon.
question, sir. Yes, sir. I said the network
Go
is
ahead.
somehow, yes, sir. The network is somehow frustrating, sir. So I want to request if by chance we can have maybe your slides or any document you can send to us that we can make use of as a follow-up, sir. Thank you, sir.
I will refer you to all the textbooks. I'm sure the textbooks were recommended to you. Were they not? At the beginning,
Sir?
textbooks were recommended to you, were they not?
Yes, sir.
You can also get the information from the textbook. That is nothing extraordinary, actually. Because the network is terrible.
Yes, sir.
So, sir, I already dropped the question, sir.
Okay, okay. I can, Daniel. I can read your question. You can hear me. I can read your
Yeah,
question if you can hear me.
yeah, I can hear you, sir.
So before 1954, yeah, before 1954, we had the colony and protectorate of Nigeria. Laws that were made for the entire Nigeria were called ordinances. You know, those that were issued by the heads of the protectorate, they were by proclamations. So before 1954, not 1954 that you wrote, they were called ordinances. So at that time, there were no regional or state laws. Regional laws came in after 1954 when federalism was introduced to Nigeria. But what happened was that, it's not as if the regions now begin to create their own laws. When federalism was introduced, there was the distribution of legislative powers, just like you have it now. You have the exclusive, you have the concurrent, and you have also the residual. So those laws that were called ordinances at that time, they had to look at the content of those laws to determine where they fall. So if, for example, a law, is law made for the whole of Nigeria, it now became applicable as a federal law, became applicable as a federal law. For those ones that fall within the subject area of states only, it became applicable as residual as laws under the residual list. But it was for the regions to look at it and determine that this one applies to us. So because when the federalism was introduced, you now had the western region, you now had eastern region, and you now had the northern region. Headed by their respective premiers. So it was now for them, because at that time, you now had the distribution of legislative powers. You had the exclusive, which is for the federal powers, federal legislature. That is the subject matters that come under federal legislature. You have the concurrent, the one where both the federal and states legislators can make laws, and you now have the residual, the one where only the regions could make laws. So basically, before 1954, that's before federalism was introduced, the laws were referred to as ordinances. But from that time, in 1954, when they introduced federalism and the powers were distributed, that's legislative power distributed, now have to look at the laws that exist at that time and be able to determine that, okay, this is aviation. Aviation is federal. So it comes under federal legislature. Education, both federal and state, concurrent, local governments, state residual. So that's basically the way it was, and that was the way it was carried on to 1960, when the Nigeria came into constitutionalism. That is democracy after independence. That's in the independence constitution. So in 1961, there was a law that redesignated those laws, from being addressed as ordinances to now be addressed as acts of the federal legislature and also laws of the regions. So that's basically the way it was. I hope the explanation is clear enough.
Yes, sir.
Can we make progress now? Daniel, you hear me?
Yes, sir. Yes, I understand, sir.
Okay, thank you very much. So the next thing we want to do now is one I call the legislative process. There is a process for lawmaking. I'm sure that if you have been following discussions in the National Assembly or the state legislatures, you will have understood, basically the point we are trying to make at this time. We all know now that we have the federal legislature, that's the National Assembly, which comprises of the Senate and the House of Reps. And we also know that the states also have their own legislative houses. So this that we want to look into now has to do with the process by which laws are made in both legislative houses, which is called addressed at the legislative process. Now, basically, you understand that the legislature or the legislature has power to make laws both for the country, that is if it's the National Assembly, that's the federal legislature, and for the states by the state houses of assembly. You will note one that they don't have powers to make any law to oust or which purpose to oust the jurisdiction of a court of law or tribunal established by law. So they can't make law. Unlike the military can make law to oust the jurisdiction of the court, but the legislature under a civilian democratic regime can make all laws, but they cannot make law to oust the jurisdiction of a court. Then, with respect to criminal offenses, I'm sure you might have come across it in your studies that no law can be made, to make an action criminal, to have retrospective effects. So that's very fundamental and is covered by the Constitution, especially the fundamental rights provision of fair hearing in the Constitution. Now, talking about the judicial process, the legislative process, you have to refer to sections 58, 59, and 100 of the Constitution. So, lawmaking begins with the introduction of a bill. So when somebody, maybe the federal government or any person wants a policy put in place by way of law, the person will prepare a bill which will be presented to the legislative house. Now there are two types of bills. There is the ordinary bills, and there's also the money bills. Now for ordinary bills, the bill is introduced, in the Senate or the House of Representatives. So the bill can emanate from either the Senate or the House of Representatives. We are discussing the federal provision now. The bill can emanate either from the House of Assembly or from the Senate. And the bill may either be a private bill that is introduced by a private member of any of the bodies, which is intended to benefit the limited interests of a section of society. So, and it may also be a public bill affecting the interests of the public at large. So it can be a private bill, which is intended to benefit a particular section. For example, people have brought bills to the House for the establishment of maybe university in their area or one kind of institution or the other. So that's private. But if it's a public bill, the subject matter would be one that benefits the entire country. So the bill is introduced, maybe through the chairman of the appropriate standing committee. You know that there are several committees in the legislative houses, whether it's in the federal legislative house or the state legislative house, covering several subject matters. So, for example, if the bill has to do with environment, it could be that the chairman of the committee on environment will be the one to introduce it. Then any member of the house can also introduce a bill, as a private member can introduce a bill to the house. Now, a bill, before it becomes law, passes through some stages. So the first stage, which is called the first reading, actually, it's called the first reading. That's the point at which the bill is first read, introduced to the House and first read to the members of the legislative body. So, and the objective at this point is just to introduce the subject of the bill. Just want the members to know, what the bill is all about. So at this point, there is no discussion on the bill. It just introduced to them, no discussion at all. And that is the first reading. Then, after the first reading, it moves to the second reading. And the second reading is at the point where the bill is read and debated. The bill is read and debated. At this point, the content and purpose of the bill are defined, and the merits are also debated extensively, and they're urged on the House. This is the point where the people introducing the bill, will be able to argue, for in support of the bill, and all members will be given opportunity to also speak on the bill. Some may also want to introduce amendments, to the bill. So, and that's the second reading. Where during this debate, it is found out that the bill does not have support, then the bill dies at that point in time. Because the debate will show whether it has support of majority of members of the House or not. If it does not have support of majority members of the House after debate, then the bill will die at that point. But if the bill has support of members of the legislative house, then the bill will not be referred to a committee. I told you before now that the legislative house has committees, so many of them, on different subject matters. They have committee on judiciary, committee on Nigeria, committee on education, committee on aviation, committee on mention it, all the subject matters that come within the purview of the legislative body. Subject matters where they have power to legislate. So the bill will now be, referred to the relevant committee. So it is the committee that will now also look at the bill in greater details. You look at it from a technical point. In fact, there are times that a committee will invite experts, to come and discuss the bill, make their input and and the rest of them. Usually once a bill passes the second stage and gets to committee stage, there is hope that the bill will eventually uh, uh, become law. Hope. I'm saying hope. I'm not saying certainty. So the committee will tie the loose ends and will incorporate all the suggested amendments. At the second stage, that's the second reading. That's when it will be debated. So many people would have brought in their own suggestions because they will have been given copies, at the first reading when it is introduced. They just tell them this bill is on this to achieve this, and each person has a copy. So they now have it to go and study it and come up with their own position on it. And the position is what is brought for the second reading. So once the bill scales the second reading, then it is passed on to the committee. The committee will now sit down, will look at the bill, based on all the suggestions and amendments. The committee may invite experts, to have a sitting to discuss it and make also their own suggestions. So they tie the loose ends, like dotting the i's and crossing the t's. So once the committee has done that, then the committee reports back to the House, and that's the one they call the report stage. That's the report stage. The committee reports back to the House, brings the document back as already deliberated and amended. So in case members of the House may also want to do any further on this. And once this is done and the amendments have been noted, then the bill goes to the third reading, and the third and final reading. And what is done at this stage is to read the bill, as amended. Read the bill as amended and agree on the version. Agree on the agreed version. Agree on the version that has been produced. That is after the report stage. The bill will have taken back to the House by the committee, reported to the committee. So at that point, what the committee has brought back to the House, members of the House as a whole will discuss it again, look through it. So if they have any further amendment that they want to make, they will make it. And once that has been done, then it now come back. The document is taken away, amended based on what transpires at the report stage. Then it comes back for the third and final reading. The third and final reading is to read the bill as agreed in terms of content. All the corrections that have been made up till the report stage, they read it. And at this point, no further amendments may be entertained at this stage. So once the content is already agreed, in terms of what has been discussed, even up to the report stage, then the bill will now be passed by a simple majority. So for it to become law, after the content has been agreed, that is the third stage, which is the third reading. For it to become law, it will have to be passed by a simple majority of the members present and voting in the House, where it originated. So if, for example, the bill originated from the Senate, I told you that a bill can originate from either the Senate or the House of Reps. So if the bill originated from the Senate, for example, it will, after it has been passed into law by Senate, the bill will be sent to the House of Representatives. So it will go through the same process of legislation the House of Representatives. So if they also have amendments, they will introduce their amendments. And once it is passed, it is after that that it is now sent to the president for his assent. If, for example, there are gray areas that the bill, sent, that is the law now, as passed by Senate, sent to the House of Reps. If they have some gray areas that they are unable to agree with, then usually what they do is both the Senate and the House, they constitute a joint committee, to look at it and to fine-tune it so that it becomes acceptable to both parties, and it is now sent back to them to be passed into law by each of the legislative houses. And then once it has been passed to law, that is once there's an agreement, between the two houses on the amendments, then the adopted bill is then sent to the president for his assent. So the president must assent to it within 30 days of presentation. So it signals that he assents or he withhold. The president can withhold his assent, but whether he withholds or assents, he must give a feedback to the legislative house within 30 days. Now, if he assents to the bill, no problem. It becomes law that is applicable. We sign it and it becomes law, because that's the final stage by which a bill becomes law. But if he decides that the result is assent, then he must also communicate that to the legislative house, to say, please, I'm not giving my assent to this law, and it will state his reasons for not doing so. So in that kind of situation, then depending, the house may now look at the law again, the bill again, maybe incorporate suggestions of the presidency and now pass it through again to law. So let me say at this point, before I proceed, that the procedure for ordinary bills, in the National Assembly, is also the same procedure that's applicable in the states' houses of assembly. So basically, it is the same process as it is as applied at the national parliament. It also applies at the state lawmaking bodies. Now, if the president withholds his assets, what happens? What happens is that when he withholds assets, the House can override that veto, by passing the law all over again. But this time around, it will be passed by a 2/3 majority of the House. So note that when the president withholds his assets, when the president withholds his assets, then they can veto it. They can veto the president's refusal. But this time around, what they will do is that they will pass the law all over again. It must go through the same process. Both the first reading, second reading, committee stage, report stage, and third reading. But this time around, it must be passed by 2/3 majority. So that's the majority that is required to veto the president's refusal to assent to the law. So you must note that it must be a two-thirds majority and not by just passing a motion. It's not a motion of majority has it or a voice vote. It must be two-thirds majority. And for this, see the case of National Assembly and the President. National Assembly and President, 2003, 41 WRN 94. So you can see that case in D.O. Asenyi. As a matter of fact, I recommend that you read D.O. Asenyi and Nobila. In fact, any of the legal system textbooks. I don't know if Prof gave you the list, the reading, the textbooks that you need to read. The idea was saying you can buy that. There is Osita Namani, Ogbu, and then also there is Obila. The Obila is the locus classicus. So you pick all the knowledge from all of them. Yeah. So in that case, that's the National Assembly and the president. When the president, refused assent, the House, in trying to veto the president's refusal, only passed the motion. But when the matter got to court, the court said that no, that it must be by a two-thirds majority. So a motion is not sufficient. It must be by a two-thirds majority of its membership. And it's not about ordinary quorum. It must be two-thirds of the members of the House, not of the members present. So to get a veto, to overturn the president's veto, then they must get two-thirds of their members to override it. So that is that for ordinary bills. Any question? One hand is up. Keneshuku Agbo. Is this recently done or perhaps there before now?
Good afternoon, sir.
Afternoon.
Yes, sir. Thank you so much. I wanted to ask, you made mention that if the bill was made in a house, for instance, the Senate, it will be passed again to the other house. So what if the other house did not accept it? Is the bill still going to
If the other house rejects it totally, then it won't pass.
Okay,
But
sir.
if the other house rejects it totally, it won't pass because it requires a concurrence of both houses for us to have a federal law. So the bill can emanate from either Senate. When it goes through Senate and Senate passes into law, then it will be sent to House of Reps that will also take it through the same process. Now it could happen that the House of Reps may not necessarily object, to the principles of that bill. They may accept that the bill is good, it should pass into law, but they may not accept some of the provisions, maybe the way it's phrased, and the rest of them. Or maybe there is a particular aspect of it that they don't like or they don't want. So usually what happens is that both houses, for example, if it's a matter on education, for example, so they can get their respective committees on education to now sit down to reconcile those provisions, and come to a common position. And once they do come to common position, then the process will pass and the law will now be passed as reconciled by both parties. But if they can't agree, then the law will not pass because the law requires that for a federal law to pass, because we have a bicameral legislature, once one house passes it, it must be passed on to the other house that must also pass it before it can become law, and it should now be sent to the president. So if the bill emanates from the House of Reps. It will go through the House of Reps. Once they are through with it, they'll send it to the Senate. The Senate must also approve it before it can go. So if they have differences, they have a way of reconciling their differences, as long as the other house does not, in principle, object to the substance of the law itself. I hope that explains it.
Yes, sir. Thank you, sir. So this process is after the third and final reading, right?
Of course. They must pass it. It must be after the third and final reading. They must pass it at one legislative house. They will now carry it and send it to the other legislative house.
Yes, sir. Thank you so much, sir.
You're welcome. So for money bills, money bills, has to do with the one we call appropriation bill or supplementary bill, when the government is sending the budget. For example, I think the budget has been sent to the house now. I don't know whether it's been passed. I can't recall, but I recall that before the end of the year, there were complaints by people that the year has ended, they have not sent the budget, and that even the one that they did the previous year, the budget is a certain percentage implemented and the rest of them. So when a bill has to do with appropriation, the spending of money, it's either one, it has to do with spending of money or withdrawal of money. Anything that has to do with money is a money bill. That's one. The secondly, if it's a bill for the imposition or increase in any tax, whether duty or fee, reduction, cancellation, or withdrawal, it has to do with money too. So it's a money bill. So those are so those ones are money bills, like the appropriation bill is a money bill. Then any bill to impose a tax or increase tax or impose a duty or a fee, they are money bills and they have their own procedure. So note that a money bill, goes through the same process as an ordinary bill. Goes through the process as an ordinary bill. It goes through first reading, second reading, committee stage, report stage, and third reading. So, but when it comes to money bills, it has to be passed by both houses too. But where, for example, one house passed it and the other house does not do so within a period of 2 months from the commencement of the financial year, the president of the Senate will, or shall, within 14 days, arrange for and convene a meeting of the Joint Finance Committee to examine the bill with a view to resolving the differences between the houses. I spoke about that procedure of the houses reconciling, their differences. But in the case of a money bill, there's a period within which they have to do that. For ordinary bills, it may not be immediate, but for money bills, it has to be done within a period of time. So if after 2 months, within 2 months from the commencement of the financial year, and they have not agreed, then the President of the Senate, within 14 days, we arrange for and convene a meeting of the Joint Finance Committee to examine the bill with a view to resolving the differences between the two houses. Just like I stated, resolution of differences is the same thing but because of money has to be spent, and it can't be left open, without restriction as to the period of time within which pass. So where there are differences and it's not been done, so within 2 months of the beginning of financial year, then the President of Senate must within 14 days arrange for the joint committee. Both houses have their own committees. Like I told you, they have committee on education, environment, aviation, whatnot. Everything, they have their committees. So in this case, the Senate president will bring the two committees together, the joint finance committees of both houses. So they will look at it and try to resolve their differences. Now, if the committee fails to resolve the differences, then the bill shall be presented to the National Assembly sitting at a joint meeting. So if the committees fail to resolve the differences, then they will have a sitting of the assembly. That's where you have all of them, both Senate and members of the reps sitting. They have a sitting of the assembly, and to now have a look at it. And the bill is then passed as such joint meeting, presented to the president for assent. So basically, it's the same procedure as done for ordinary bills, but because it's a matter of money, you can't delay the matter of money. If you take a law or a bill to the house. In fact, there are bills that have been sent to legislative houses that one house will not even treat it. After that time, the time of that house has elapsed, it is still there. If another person is interested, they'll bring it up again during the time of another legislative house. And that's because that one has nothing to do with money spending. But money is very important. The country must be run. So they have to do that very, 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 very quickly. So that's why there's provision, that introduces a measure of urgency to ensure that it is taken care of very quickly. So now, once they have not agreed, if the joint committee is unable to agree, then it will be brought before the whole house. Okay, Kaneshuku, your hand is up again. Let me attend to you.
Okay, sir. Yes, sir. I wanted to ask concerning the sitting of the both houses. So, is the for the bill to be passed, is it going to be by a 2/3 majority, like for it to be agreed upon, like when both of them
No,
come together?
no. It's ordinary majority. The 2/3 applies only when you have to overturn the veto of the president. Do you understand? It's ordinary majority. To pass the bill is ordinary simple majority. Okay, because it's simple majority. It's simple majority. So the 2/3 applies only when the House needs to overturn the presidential veto. When the law has been passed by the House and the president vetoes it, then if to overturn that veto, the House needs 2/3 majority of the members and not of members present. There's a difference. Because not all members are present at all times at legislative sittings. But when it has to do with overturning the president's veto, then they must have 2/3 majority of the members, elected members of the House. Is that
Yes, sir. I still want to ask, like in
right?
peculiar cases like this now, whereby the both houses come together and then the president still like give his veto that is not assenting to it, are they still going to convene and give a two-third majority to pass it to law. Do you get me, sir?
Yes, yes. Yes, they will convene now. They will convene. But when they convene, I think they will convene as each, not necessarily.
I can't hear you clearly, sir.
Sorry, guys, he's been cut off. So he wants to try to join again.
Hello, can I be heard?
Yes.
Okay. Sorry, the network has been very terrible. So, can I you have I answered
Sir,
your question?
no, sir. That was when the network interrupted.
Yeah. Okay, but the question is as to, can you please repeat the question?
Okay, I said that in the situation whereby after the two houses have convened and then the president did not assent to the bill, are they still going to come together to do a two-third majority voting on it?
No, I don't think so. I think each house will have to do their. The coming together is a matter of convenience to be able to resolve, as between themselves. So because by law, each house, stands, for itself.
Okay, sir. Thank you,
Yeah,
sir. One final question, please.
right.
So you say that the president is supposed to like communicate his assent or withholder of assent in 30 days. What if that 30 days elapsed and there was no communication from his end and he did not assent to the bill? Say he's withholding his assent. What will happen, sir?
Well, if refuse to do that, that by implication means that he has not assented. So the house can proceed to take the necessary step. But the president would constitutionally, because that itself is going to be an abuse of power, not to indicate. The guy must indicate whether he assents or he does not assent. And I've not experienced it at any point in time that the president will not respond within that period of time. It's a constitutional matter, so president will be very wary not to take the necessary step. But in my own opinion, if it does happen, then the House can take it as a refusal of assent and proceed to take steps to overturn that refusal.
Okay, sir. Thank you so much, sir.
You're welcome. So, so I think the point to make here is that the same rules governing treatment of veto of ordinary bill also apply to that of the money bills. So then also note that as regards states, there is no specific provision, for money bills for states. So it is taking that at any rate, what they do is to pass the law. That is their budgets, following the procedure that they use for ordinary bills. So once the bill is passed into law, then it has to be authenticated, and that is done under the Acts Authentication Act. And what happens is that the clerk of National Assembly, has a duty now to classify the bill, that's recording the bills and acts, then do the classification, the numbering and printing. That's be printed. Then once it's been enacted, it will authenticate the bill for signature. So what it does is it will prepare a copy of the bill as passed by both houses of the assembly, embodying any amendment that may have been agreed to. So then we will endorse the bill, sign a certificate that the copy has prepared and as prescribed, and true copy of the bill. So we also prepare a schedule of the bills, passed by the assembly for assent for the president's assent. And once that has been done, then it will be passed on to the president for president's signature. That is the endorsement. So once the clerk certifies it, then the certification of the clerk is conclusive for all purposes to say that the content is what has been agreed to. That is what is passed into law. So if, for example, a law is passed, as against the president's veto, then there must also be a certification, by the uh, excuse me. So if law is passed, that is against the veto. Once the president vetoes it and it returns to the House, and it is now passed by two-thirds majority, then there must also be certification to that effect by the president of the Senate. Certification to that effect by the president of the Senate. Then the documents are presented to the president, for his assent as usually done. Normally you will present maybe 2 copies, which the president will assent. Then they have where they keep the copies. Then they proceed to now have it gazetted. So and the gazetted copy is conclusive of the law. So basically that's about that. All other things, the clerk will take the copy records. That's standard anyway. The clerk must have a copy. They send the copy to the CJ because CJ is more like a enforcer of the law. And from there, I think they will now circulate it to it will have to be printed anyway by the government printer. After it will be printed by the government printer, and it will now be made public. So other copies are made from the gazetted copy. So thereby confirming the authenticity of the law and as well as its content. So that's that for the legislative process. No, so now we want to look at the legislative process under the military. Although we don't pray for a military government, but because it's a reality, especially in West Africa now, and that we have had that experience before, we also should at least have a knowledge of it. Well, for military governments, they arrogate ultimate power to themselves. So, this is contrary to what happens under civilian governments, where you have elected representatives making laws. The military, once they assume power, they are once they amend, they can suspend all or any part of the constitution by decrees. We have already spoken about that, and they do that. That is the standard thing they always do. They always have their law. They want this constitution suspension and modification decree. Each time they come in, they do that. They have the one of 1984, 1993. So anytime the military comes in, the first thing they do is to suspend the constitution using the law, constitution suspension and modification decree. And once that is done, and like we also explained, somebody asked a question at the last time talking about the hierarchy of laws under military government. So, and I did explain that even the unsuspended parts of the constitution is also subject to decrees. So even though it's not suspended, they can make a decree, because the parts are not suspended. Okay, Folusha, Ani Fowoshe, can I have your question, please?
Um, Good evening, sir.
Good evening,
So,
position.
when you talked about the president's signature, the endorsement is also the assent, right?
Of course,
All
when
right.
the president assents, you know, when the president assents, he says, "I agree to it." So that is is his own assent. But the law itself, if you check, if you go to the library and you see the laws as passed, you see that it is the assembly that signs it. Oh, it is the clerk. The clerk just more like a cover letter, a cover document for the law itself. The law stands apart. So the clerk does it, and if you check it, you see the signature of, of the clerk. Or perhaps it could be the president of the Senate, depending on where the law emanates from. But the endorsement of the president is just to endorse, to say, yes, the law is acceptable to us and I assent to it.
All right. Thank you, sir. I also wanted to ask, sir, for public bills, when are they opened to the public? Because I know that I think at some point in time they open it up to the public. Don't know, is it public bills or other bills?
So the public bills are bills that that by their contents apply to the entirety of Nigeria. You understand? So it's not about when they are opened. If, for example, as students, as students, if you want a particular law passed, you will have to maybe prepare it. Then you have to liaise and lobby, a member of the house who will show interest in the law. Are you with me? And that's the person that will move for the bill to be introduced. So if you talk about public bills, you are talking about bills that apply in content to the whole of Nigeria, not to a particular section of Nigeria. For example, if it's a bill on education, that you apply uh, generally, that is public. If it's a bill that applies specifically, if you follow legislative proceedings, you find out that people introduce bills that have to do with specific area in Nigeria. Maybe a law to create university in particular states. A law to create university. So, and we had a number of them passed by the House and now sent to the government. Even the government wants to set up schools and the rest of them. These schools must be backed by law. So government also can introduce bills, and send it to the House, for the bills to be considered for passing into law. So that's that.
All right. Thank you. Just to confirm, yes, apart from lobbying, before the bill is passed, there is no stage at all, where the bill is opened for public to comment on it or say anything, right? Or read
That's the committee.
it.
That's the committee stage.
Okay, so
That's the committee stage. That when a bill is passed to the committee, then the public, for example, depending if it's a bill on something that is new or which they think they should get contributions from the public, they always have sittings, committee sittings. Sometimes they publish in the papers to ask for memoranda from people. Are you with me? They can even invite experts. If, for example, it's a bill having to do with aviation, or any aspect of Nigerian life, maybe insurance, they can, when it gets to committee, the committee will invite experts They can invite experts. They can even put up an advert in the papers. That's why as students, you don't limit your learning to only what you hear in class. Because there are a lot of things that you come across in newspaper publications and the rest of them. Unfortunately, people don't read newspapers again. If there is going to be a committee sitting, they publish it in the papers and they invite memoranda from the public. You can even go there. If you have what you want to, you submit your memorandum and you'll be given the opportunity to speak to it. So that's the point at which members of the public can intervene. That's the point at which you can intervene. If, for example, you are aware that a bill is being introduced, normally when the bill is read, that's the first reading, it's also publicized. Although we don't get to hear many of those things, but it's publicized, and you find that this person that is moving, for that bill, to become law. You can, if you have any opinion, you can write your opinion and send to the person by your suggestion. But the official period at which members of the public are given opportunity, to intervene is when the committee sits. So normally there is what they call public sitting. Public sitting. The committee feels that this is one that you need to invite people from outside the legislative house. They declare they want a public sitting. For example, the constitution that has been amended in bits, they have been having public sittings from one geopolitical zone to another. I'm aware of what that they did in Uyo and other places because I have a friend who is part of that committee. So they invite people, they invite experts. So the experts will submit their memorandum and they can also come there and speak to it and render their own opinion. So the committee may invite people, specifically, when they say, okay, they know that this person is an expert in this area. Okay, please come and speak to us on this. Then they may even open it up and ask people to send in their opinions and ideas about the proposed law or amendments, because it can also be an amendment to an existing law. Is that
All right,
okay?
thank you. Yes, sir. I just wanted to confirm that.
Yeah, thank you very, very much. So we'll be through very soon, just to wrap up, because I can see that our time is up, but we need to finish this aspect. This is the last part. So I already made the point that the military, they also even the unsuspended parts. That there are parts that are suspended. There are parts that will be modified. So that law will modify a lot of part of the constitution. And part of what is suspended is they will suspend legislature. There's no legislature again. So all this first reading, second reading, commission referral, it will not apply. Keneshuku, you are back. Let me hear you.
Okay, thank you, sir. I just wanted to confirm, what is the difference between public and ordinary law? Are they the same thing?
Ordinary, there's nothing about ordinary law. Do you mention ordinary law? Yeah. No, public
Like, I mean bills, sir.
and private. Private. Public as against private. There's no ordinary law. We are talking about ordinary bills and money bills. Don't mix them up. Ordinary bills and money bills.
Yes, I wanted to ask the difference. Is there any difference between ordinary bills and public bills? Or are they the same thing?
So ordinary. See, the decision is as between ordinary bills and money bills. Are you with me? But
Sir.
private bill, see, ordinary bills, are you with me? Are the bills that have nothing to do with money. They are not for spending of money or for introducing any budget or for levying monetary imposition on people. Are you with me? That is ordinary. The money bills are the ones that, not like budgets. Government wants to spend money. It has to be approved by the House. Budget. Government wants to impose tax. It has to be approved. There was a tax. Government wants to withdraw it. It has to be approved. That's money based. So, but you are talking about ordinary bills and money bills. But you are talking about private bills and public bills. Private bill having to do with bill, a proposed law that does not apply to the entire country as a whole. You know, a proposed law that applies to a particular section, a particular subject matter. It does not apply to the entire country as a whole. But when it is a public bill, the content will apply to the entire country as a whole. Well, it's public. Somebody can bring a private bill and say, we make a law that they should create technique another technique in Ekiti State, in those states. No, that's private because it is limited to a particular section. It is not of general application. If I may use that word, no, it is not of general application. So the distinction is between a private bill and a public bill. So, and if a member introduces a private bill, that bill benefits limited interests of a section of the country, limited interest of a section of a country. You know, so that is a private bill. But if it's a public bill, the public bill applies to the whole country. And usually you have public bills being introduced by government, you know, by government. For example, this tax law came in through a public bill because tax law applies to the entirety of Nigeria. It's not tax law just for people in Ekiti State or people in Lagos State. It's for the whole of Nigeria. But if the bill comes in, as, for example, federal government is not likely to bring a bill, you know, that will serve only a private or limited section or limited interest of society. No. For example, you can bring a bill only to take care of women, for example. You know, there was a bill where they are saying women should be given a certain percentage of elective posts. That one is private because it applies to only a limited interests of a section of society, you know. So that's basically the point we are making.
Thank you so much, sir. I get it now, sir.
So I want us to quickly round up. So basically, I was talking about the process under the military government. But before that, I think somebody spoke of the hierarchy of laws in the military regime. And number one is the constitutional suspension and modification decree. That's the first law they make anyway, to suspend the constitution and also to notify it as they want. Then after that, you know, the decrees, you know, we made the point too that even the summary provisions of the constitution are subject to the decrees. So after the first one, the decrees, then after that, you have the summary provisions of the constitution. You know, those parts of the constitution that are not suspended, they come after the decrees. So mean that they are subject to the decrees. Then after that, the Act of National Assembly. All the laws that National Assembly have made, which are not be suspended, which apply generally. For example, tax law. If a military government comes in now, they will still apply the tax law, even though they may subsequently want to amend it in their own way. But they won't suspend the tax law because it's better for the running of the country. And it's an act of the National Assembly. Then the edicts of the state military governments, because the edicts of going to come after the national laws, because national laws should take precedence over state laws. So the national laws take precedence over the military laws of the states, which are the edicts. And after that, you now have the laws of the State House of Assembly. So because those laws too, they are still extant as long as they have not been suspended. So basically, the military government, they make their own laws. They have their legislative body. Maybe the Supreme Military Council. So they issue at the federal level, the council issues the laws for the entire country, and at the state, the state administrators also they make laws, but their laws they must seek the authorization of the head of state, for to make that law. They must let us know I want to make this law. So their law is subject to the consent of the head of state. Unlike in the civilian regime, whereby the legislators make their laws without seeking the consent of the of the federal government. So even though the division of powers is still there, but the state's military laws they must still seek consent of the federal military. Who are those people disturbing us now? So basically, once they also make their laws, they also gazette it, and it becomes the law for the country. So they don't have any special procedure, for making laws, just like you have for the National Assembly. And no court can inquire as to whether for example, in the military government, once the state administrator, if he makes the law, but no court will ask them to say, okay, this one, you have acted outside concurrently and the rest of them. So they are generally subject to the powers of the federal government. So that is all in summary for Nigerian legislation. Any question? We are at about 24 minutes beyond time. So if there's no question, again, I can't see any hands up. I take it that we bring the lecture to a close at this point in time. So thank you very much for being in class. See you again next week, Wednesday. Thank you.
Thank you so much, sir.
Thank you,
You're
sir.
Have a
welcome.
nice day, sir.
Yeah,
Love
you
you.
too. Have a nice weekend. Bye-bye.
Sir.